Hi, welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law. We cover 4 fundamental questions about property and property law in this series. Today, we are talking about the third question, the category of using property. And today I wanted to call your attention to a legal treatise called the Third Restatement of Property. It dealt specifically with servitudes. Another video in the series defines servitudes to include a broad array of burdens on land, including various types of easements and covenants, also articulated in other videos in this series. It may be interesting to note that the term servitude is hardly used either by state legislatures or by courts as a catch-all category that covers both easements and covenants. However, the Third Restatement of Property, which was adopted by the American Law Institute in the year 2000, offers a different approach. So maybe I should say what a restatement is before we get too far. So as I said, a restatement is a legal treatise, or like a legal treatise. It restates existing law, but it is also supposed to clarify black letter principles. Restatements are relied on by judges and even by policymakers in interpreting common law. The Third Restatement of Property on servitudes specifically was a somewhat controversial restatement. It really aimed to clarify centuries of case law about covenants and easements and other things that would be considered servitudes, such as profits. The reason the restatement was controversial is that it categorizes all of these types of restrictions on land as servitudes. It urges us to consider all of them under very similar principles. In particular, for covenants, it eliminates the touch and concern requirement that we discuss in the video about the elements of a covenant. The restatement takes a particular view about the enforceability of servitudes as well. It says that enforceability should be the default. In other words, that we should want to enforce servitudes, except in a few scenarios. So if the servitude is arbitrary, spiteful, or capricious, if it unreasonably burdens a fundamental constitutional right, if it imposes an unreasonable restraint on alienation or unfair trade or competition, or is unconscionable, then the Third Restatement says we should not enforce the servitude. For all other situations, though, it says we should. This approach is simpler than other approaches that courts have used in the past. As other videos in this series suggest, there are similarities between different types of servitudes, and those similarities might suggest that servitudes should be treated equally under these very broad principles. In addition, there's also confusion with legal doctrine, particularly with covenants and the way covenants are enforced. I ask you to consider, though, why courts have not necessarily fully embraced the approach of the Third Restatement since it was adopted in 2000. Well, when I was in law school, I was told that we have a very conservative profession, which is very slow to change. And as you're watching this, you might see that as a source of frustration. You might just accept that. On the other hand, you might be one of those, whether you are a lawyer or maybe a judge later in life, who says that you might want to help to compel change a little bit more quickly. Right now, I am serving as a reporter for the Fourth Restatement of Property, and we will be considering how we deal with the Third Restatement on servitudes. I will be super interested to see whether the American Law Institute today and our group of reporters pushes for the continuation of this standard, the modern standard of servitudes, or if we fall back on traditional doctrine. So I guess we will wait and see. In the meantime, I will leave it there. I look forward to connecting with you on Twitter or through my website, and I will see you next time.